pass this bill with unanimous vote. Thank you.
The motion for consideration of the bill is now open for discussion. I now call upon the members whose names have been received for participation in the discussion. Dr. Amar Patnaik.
Thank you, Madam Vice Chairperson. And thank you, Honorable Minister. I think what you forgot to probably mention, that this is one of the most landmark legislations of our country ever after independence. Because as you said very correctly, this is protecting the data of 141.4 billion Indians, male, female, child, everyone's. So this is actually a bill which should have been discussed. I would have been very happy if the other side people would have been there to contribute, and probably he would have taken some suggestions to the rules. There are very, as I said, the most important thing is that this right to privacy has been read into the Constitution by the Puttaswamy judgment as a fundamental right. So this right is now given to citizens by the Constitution. What the bill merely does is that it expands this right, how to exercise it. Otherwise, everyone would have to go to the Supreme Court for implementing that right. Now, the point is whether, while remaining within the four corners of this judgment, which he was referring to, Honorable Minister was referring to, you know, the purpose limitation, collection limitation, storage limitation, accountability, equality, all these. Now, I will also evaluate it from this point of view, from within this framework. There are several good things about the bill, about which I will first mention. And the most important thing, after 6 years, after a lot of deliberation, we have finally got a law. And mind you, this is a law of the largest democracy in the world. A law for one of the largest countries in the world, the other most populous country, I do not know whether they are more than us or not, but they do not have a privacy law at all. No citizen enjoys privacy in China. So this should be welcome. I wholeheartedly congratulate the government, the minister, the Prime Minister for this entire thing. Second, as you pointed out, this is a gender-neutral law. For the first time, the word "her" has been used, and this is in line with our Honorable Chief Minister Naveen Patnaik's entire model of governance, which is to empower the women more and more, and this will go on to actually empower our women, which falls in line with our ideology. The third point is that the Supreme Court judgment of Puttaswamy, while saying that this is a fundamental right, personal data has to be protected, also said that we have to take advantage of this data for growth of the digital economy, for growth of our country. So balance had to be arrived at. There should be no regulatory overload. So in this point, I support the minister and the bill and the government for no compliance overload at the threshold itself, at the beginning. The earlier versions had a compliance overload at the beginning. The next one, it is very simple, principle-based, because rules should actually take care of the procedures, which was probably not there in the earlier versions of the bill, or even in EU GDPR to that extent. The third thing which I want to point out is illustrations. The bill, for the first time, I have not seen a bill in government which writes illustrations. The next point is, it has created a strong deterrence against data breach. While making the threshold easy, what is not stymieing innovation, it has made the punishments harsh so that people will try to build their own mechanisms to protect the data of citizens. It has removed the concept of anonymized data. Now, I'll explain this in one line, that they were using the previous versions, or even EU GDPR uses the fact that if you can encrypt your data, then the others can use it. But this bill, to that extent, I think this is a very positive thing. It treats data, personal data per se, whether anonymized or non-anonymized. If it can be related to that particular person, then I think it falls under the regulations of this particular bill. The next point is alternate dispute redressal at section clause 31. He referred to it. It is very nice. And also, I would like to say the point which Honorable Minister mentioned about voluntary disclosure, voluntary compliance. So now I will refer to that particular provision straight away. And that particular provision is at section clause 32. Now I'll refer to clause 32.4. The clause 32.4 says, the acceptance of the voluntary undertaking by the board shall constitute a bar on proceedings under the provisions of this act as regards the contents of the voluntary undertaking, except in cases covered by subsection 5. This is something like a commitment under the competition law which we brought in. But the point is, how can it be a bar if the data principal himself or herself is not satisfied? This is something that I think you have to examine. Now I'll come to some of the suggestions which I hope the Honorable Minister will take it in stride and probably bring in rules to incorporate some of this. While we have waxed eloquent about data protection, the words which I didn't find in the bill is privacy. The Supreme Court's judgment was full of informational privacy within inverted commas all over. This privacy word is missing in the bill. Compensation is missing in the bill. Harm is missing in the bill. Why harm is important, which I know it has been excluded because of a purpose, but I will make my argument why it is probably necessary. The clause 2O, which is the definitions, it incorporates, it outlines gain means, loss means. It basically interprets the entire data breach in financial terms. What happens if there is a reputational loss because of a data breach? What happens if there is a bodily injury? Now you might say that you can use the Criminal Procedure Code, CRPC, and IPC and CRPC to try that person. But it has to be read with this particular act in order to make the provision stronger and stringent for such kind of breaches, because a reputational breach for a woman is much stronger than a man. And a reputational breach might even lead to suicides. So this is a point which I wish the Honorable Minister would clarify. The next point is relating to, again, Section 3, relating to processing. So only of Indians, it gives the description. So my clarification from the Honorable Minister would be, any person, in our fundamental rights, the word is person, not citizen. So any person enjoys fundamental rights in our country. So if there is if Indians or anyone, what about other countries' data processed in India? And if there is a breach, what happens to that? Now I come straight to, Honorable Minister spoke about data minimization as one of the guiding principles, but unfortunately in Section 4.2, there is no such provision. It is only limited to purpose limitation. Data minimization is at the core of, as a preventive measure against future data breaches. I think this is something which probably has been missed out somewhere, which was there in the earlier version of the bill. I will now come to Section 7. Section 7, Clause 7, certain legitimate uses, and there 7B2, page number 6. It says that for the state and any instrumentalities to provide or issue to the data principal, a data fiduciary may process personal data of a data principal for any of the following. Namely, they have given the things, and one of the section, that is subsection B, says, for the state and any of its instrumentalities to provide or issue to the data principal such subsidy, benefit, service, certificate, license or permit as may be prescribed where, and then number 2, such personal data is available in digital form or in non-digital form and digitized subsequently from, I'm not reading the full thing, to say, which is maintained by the state or any of its instrumentalities and is notified by the central government. Now, I fail to understand why it is to be notified by the central government. There are state laws, states give benefits, states give the same thing. States give subsidy, benefit, service, certificate, license. Lot of these things, permit, everything is given by the state, and they are governed by the state laws, state schemes, and why should it be notified by the central government? And therefore, my plea is that here somewhere, appropriate government, whether central and state, has to be brought into the bill. And number 2, the adjudication mechanism or the grievance redressal mechanism has to be therefore linked to that particular thing, that the state level data protection boards have to be set up. Honorable Minister said that digital by design. I think privacy by design is more important, because even 25% of people in rural areas do not have access to a device or internet. It's a rural Orissa, let us say, the total internet intensity is, I think, 36%. So I think this is something one has to think about. And my argument, once again, one of the conditions for selection of chairman, you have said that he may be proficient in consumer protection. So you admit that consumer protection law is similar, in which case consumer protection authorities are available at the district level itself. And they do deal with cases in which e-commerce platforms are supplying and fail to give the kind of right kind of food, right kind of services.
Honorable member, please conclude.
Then I come to a point relating to the power of the government. I think the power of the government, that is section 10, there should be, I think it has come in the rules, the central government or the board should have the power to conduct audits and inspections at any time. This is a provision probably which has been missed out. The another point again at section 9.5, clause 9.5, the central government may, if satisfied that the data fiduciary has ensured that this processing personal for children. Now the state governments have equal right. Why should it not be the state government? If a child's privacy has been affected in Malkangiri or in, let's say, in Kashmir, in Ladakh, why should the central government be all the time, one has to run to get it notified or to satisfy that the data fiduciary has made a mistake? The next point is relating to section 17. Minister talked about exemptions. But I think the proportionality aspect, which is one of the foundations of the Puttaswamy judgment, is not mentioned in this. I would suggest this has to come somewhere here if it will be tested against this Puttaswamy judgment later in the constitutional courts. Reasonableness, fairness, necessity, and proportionality. These four have to come in. We may have the least number of exemptions, but we need to, while imposing these particular exemptions, it should not be blanket, but as narrow as possible. And the restrictions at 17.2a, which has been mentioned, I think should be restricted to Article 19.2 reasonable restrictions, which is given. I carry Article 19.2, in which one of the provisions where reasonable restrictions shall apply is decency or morality. Decency or morality cannot be done in terms of gain or loss. So this should actually feature somewhere in terms of, the breach of data leading to indecency, leading to or immoral activities, leading to reputational loss, leading to bodily injury or anything more. The another point which I would like to say, Honorable Vice Chairman, sir, Vice Chairman, ma'am, is the fact that there is at page 12, 3, this is section, 17. So 17.3, there has been a carve-out, an exemption which has been given for startups. And the carve-out has been given for, maintaining the confidentiality, integrity of the data. I think for any startup, even confidentiality, integrity should be a feature. They have to do this much basic minimum. Carve-out could be given to them to reduce the compliance cost. But carve-out may not be given to them for maintaining the confidentiality, integrity, and completeness of the data. Because this data, if it is incomplete, using generative AI, it can give you completely different relations and discrimination
Honorable
may continue.
member,
So the Honorable Minister may kindly consider. Ma'am, I'll just take one more minute
seconds.
with Minister's permission. The Chair's permission, ma'am. I was referring to the BJP side. Ma'am, by the way, the Minister is also representing Odisha, so he's with us. Sorry. So the point here is relating to the powers, functions, and procedures to be followed by the board. Clause 27. Now, this particular board will be sitting in judgment over possible data breaches by organizations like central government, state government, Chief Minister's Office, Supreme Court, High Court, Chief Election Commissioner, CAG, all the constitutional bodies. So do you think the current structure which has been prescribed would be sufficient to handle data breach by these organizations who are themselves constitutional bodies? Constitutional bodies. And impose penalty on them in case such a breach has happened. The appellate tribunal, I think this is an innovation they have done instead of
I call
building
upon the
another
next
tribunal.
speaker.
I support, ma'am, I'll finish this here. I support this particular thing because Honorable Minister has already clarified the RTI aspect. But in RTI aspect, I think also there is a necessity for clarifying. It says information which relates to personal information. But personal information has not been defined in the bill. It is personal data. So I think that particular clarity also has to be brought in. And the
Thank you.
penalties have to be...
Niranjan Reddy.
Ma'am, just last 30 seconds. Penalties, ma'am. Penalties in the schedule, section 33(1). The penalty for breach in observance of additional obligations in relation
Honourable
to
member,
children,
your time is up.
to children under section 9 has been made 200 crores. But, you know, penalty against children has to be much more stringent.
S.
It should be
Niranjan Reddy.
250. Thank you, ma'am.